Are non-compete clauses enforceable in employment contracts? In today's fast-paced job market, many employees are asking an important question. Are non-compete clauses enforceable in employment contracts? Just this week, discussions have intensified around this topic as more workers seek clarity on their rights. If you have signed such an agreement or are considering a job offer, this information is essential for you. Non-compete clauses are designed to prevent employees from joining competitors or starting similar businesses after leaving their jobs. However, their enforceability varies widely based on location and specific legal standards. Courts typically consider whether these clauses are reasonable in terms of duration, geographic area, and scope. For instance, in Maryland, courts apply a reasonableness test to assess non-compete agreements. This means that if you are an employee, you may have a stronger defense if the restrictions seem excessive or unfair. Recent legislative changes also reflected a shift in how non-compete clauses are viewed. In Australia, the Labour government is working towards banning these clauses altogether. Meanwhile, in Indiana, a new law will prohibit non-compete agreements for physicians starting July 1, 2025. In Massachusetts, the Non-Competition Agreement Act imposes strict requirements on non-compete agreements signed after October 1, 2018. This law includes specific notice and consideration provisions and limits enforceability against certain workers. Notably, if an employee is terminated without cause, the non-compete may not hold up in court. Employers often pursue legal action against former employees they believe may pose a competitive threat. This can include sending cease and desist letters or filing lawsuits seeking injunctions or damages. Employees facing such actions should know they have defenses available, especially if the agreement is overly broad. Non-compete clauses are part of a larger category called restrictive covenants, which also includes non-solicitation and confidentiality agreements. The enforceability of these agreements is increasingly scrutinized by courts and legislatures. To summarize, non-compete clauses can be enforceable under certain conditions, primarily when they are reasonable and comply with applicable laws. However, recent trends indicate a move toward limiting or banning these clauses to protect workers' rights and promote job mobility. If you find yourself challenged by a non-compete agreement, seeking legal advice is a wise step to assess its validity and explore possible defenses.